How long does a T visa actually take in 2026? If you look online, the answers are all over the place. If you get the wrong information, you will hit the panic button from day one. My name is Moumita Rahman, and I have been an immigration attorney for 16 years, and my office handles T visa cases every single day. In this video, I am going to show you the real T visa timeline, how long each stage usually takes, and what delays are actually normal. And at the end, I will even show you how to become a US citizen, so stay tuned. Before your T visa case is ever filed, there is actually going to be a preparation stage. And this is where the real work happens on your case. This is because the T visa does not consist of just a form. It is usually going to be a full package that contains several forms and your statement. It will also include different types of evidence. In most cases, packages will include your form I-914, which is the main T visa application, your personal declaration explaining how the trafficking happened and what you went through, evidence of the trafficking, and proof that you are inside the United States on account of trafficking, law enforcement cooperation evidence, which can include the form I-914, Supplement B, form I-765, if you are applying for work authorization, form I-192, if a waiver is needed for certain immigration issues, derivative filings for qualifying family relatives, and identity documentation with certified translations. Now, some of these documents can be prepared relatively quickly, but a few of them are responsible for the majority of time taken in preparation for your case. One of the biggest time-consuming factors is going to be your personal declaration. This is the written statement of how you explained what happened to you, how the trafficking occurred, and how it led to you being in the United States or having to remain here. Preparing the declaration can take lots of time because the details have to be just right to prove your trafficking application. Attorneys and advocates often prepare the declaration in multiple stages and may require multiple interviews so that the client can explain their experiences carefully and accurately. And because of this process, preparing the declaration alone can take a long time. It can take anywhere from a month to even several months for clients whose story is complicated and requires a lot of hand-holding to parse through the trauma. Another factor that can affect the timeline is the cooperation with law enforcement. Some applicants are able to obtain the I-914 Supplement B, which is a certification from a law enforcement agency, confirming that the applicant has been helpful in the investigation or prosecution of trafficking. And the timeline for this certification can vary from various agencies. Sometimes it can be completed in a couple of weeks if the agency is cooperative. Other times it can take several months, especially if the agency requires investigation or interviews of the applicant. For example, the Department of Labor has indicated that certifications can take approximately 3 months, while other agencies may respond faster or slower depending on their own individual timelines. Next, another document request that can cause your application to take a long time is the need to provide certified dispositions of criminal arrests. Most persons frequently do not have these documentations, and the process of obtaining these records can take time and also some digging because many people may not know where they need to go to in order to get these dispositions. A helpful tip, one that we engage in our office, is that if a client is unable to obtain dispositions, then we will go ahead and order FBI fingerprint background searches, which can sometimes also help us identify the jurisdiction of an arrest to help identify which courthouses the client would need to go to obtain the certified dispositions. And finally, some applicants will need to file the form I-192, which is a waiver used to address certain immigration issues. Preparing that waiver can take time to explain the immigration issue involved and providing supporting documentation. And depending on how complex a situation is, the I-192 can add several weeks to the preparation stage. So before your application is ever filed, the preparation stage is going to take time and requires that the declaration be carefully written, the necessary evidence be gathered, and the necessary waivers or certifications be prepared. And when you combine all of these steps together, most T visa applications will take many months to prepare. And keep in mind that if you are working with a law firm, this time probably will not include the time it takes to review and carefully vet the pieces of the application. Once your application package is ready, it is going to be mailed to USCIS. T visa applications are currently filed with the Nebraska Service Center. After USCIS receives the package, the government will enter it into their system for processing. Several different milestones can occur at this stage before a final decision is made. The first milestone is the receipt notice. This is the notice from USCIS confirming that your case has been received. The notice will contain the case receipt number, which will allow you to track your case online. The timing for this step can vary for quite a bit of time. In the fastest situations, most persons will receive their receipts within 30 days of filing. For many applicants, the receipt may take up to 6 months to receive. And in some slower situations, some people have even reported having to wait 7 months for the notice. It is also common to receive different receipt notices for the different forms that are inside of your application packet. For example, the I-914 and the I-765 will generate separate receipt notices and separate case numbers, and they do not always arrive on the same day. After the receipt notice is issued, USCIS will then schedule you for a biometrics appointment notice. Some applicants will receive an appointment to go to their nearest application support center. Others will receive a notice saying that USCIS already has biometrics on file. Both are normal. If you have to go in for an appointment, USCIS will collect fingerprints, take a photograph, and take your signature. This information is going to be used to run background checks and confirm your identity. Biometrics notices are typically issued within 3 to 4 months after your application is received, which means that you'll typically wait 1 to 3 months after you receive your receipt notice for your biometrics appointment letter. Now, keep in mind, USCIS is currently sending out biometrics appointment letters with very, very short notice, causing people to miss their appointments. USCIS is currently giving only about 7 days notice when issuing the letter, and when taking into account delays for the mail and other items, you may miss your appointment. If you do miss your appointment, simply call USCIS to request a reschedule. Next is something called a bona fide determination, which is a newer step inside of the T visa process. For applications filed on or after August 28, 2024, USCIS now conducts an early screening of the case before full adjudication. During this stage, the officer will review the application to see whether it appears legitimate on its face and whether any initial background checks raise concerns of national security. If USCIS does deem that the case is credible, 2 things can happen. First, the applicant may receive something called deferred action, which provides protection against deportation while the application is pending. Second, the applicant may receive a work authorization, and this will be issued in the category C40 and will be valid for a period of 4 years. When this step does occur, it will typically happen within 3 to 6 months after the biometrics are taken. And many attorneys are reporting that this may be issued about 6 to 12 months after the application is filed. But it is important to know 2 things about this stage. First, a bona fide determination is not a final approval of the T visa application. It is simply an early screening step while the application remains pending. Second, not every case receives a bona fide determination. The majority of applications will move forward towards a full adjudication rather than having a bona fide determination being issued. And bona fide determinations are largely going to be decided by background checks. So if your case never receives a bona fide determination, that does not mean anything is wrong with the application or that you will be denied. It simply means that you are not getting deferred action at this moment and you must wait for a final decision on your case. Now, there is one thing that could make a practical difference to the timeline. If you want to receive a work permit through the bona fide determination process, you should make sure the form I-765 is filed at the same time as your I-914. If the I-765 is not included with the original filing, it has to be submitted later after the bona fide determination notice is issued, which can add a delay to the work permit application if you are lucky enough to get a bona fide determination. At any point during this stage, USCIS may issue a request for evidence, often called an RFE. This means the officer reviewing the case needs additional information before making a final decision. Applicants are typically given 87 days to respond. Receiving an RFE does not mean that your case is weak. T visa cases often receive deeper review because trafficking claims are complex. What matters most is taking the time to put together a coherent, clear, concise, and persuasive response to the RFE. Once the response is submitted, the case returns to the officer's queue for further review, which can add additional time to your overall processing. Then, after completing a full review of your T visa application, USCIS will issue a decision. Right now, in 2026, many T visa cases are taking between 18 to 36 months from the time time the application is filed to reach a final decision. The median is around 23 to 24 months. Some cases are decided faster, some within 12 to 18 months, while others can extend closer to 3 years, especially if an RFE is issued or if the case requires more complicated review. When the T visa is approved, the applicant receives an approval notice and an I-94 showing T non-immigrant status. A new work permit is also going to be issued automatically, which is different from the C-40 category that is given with the bona fide determination. And this approval is what starts the timeline, the path from the T visa to a green card. Now, once the T visa is approved, most people will ask, when do I get my green card? And the first thing to understand is that the T visa approval does not mean that you can automatically get a green card. It also does not mean that you have to immediately apply for a green card. There is another stage that will come first, and that is living in a T visa status. When USCIS approves your status, you receive T non-immigrant status. This status is valid for up to 4 years. You also receive a work permit that is valid for the same 4-year period. During this time, you are legally living and working in the US under T status, but you cannot file for a T visa right away. In most cases, you must wait 3 years to be in T visa status before you can be eligible to apply for residency. This 3-year clock starts on the day that you are granted T visa status and on the day that your I-94 starts. During these 3 years, you must continue to meet T visa requirements, including cooperating with any reasonable request for law enforcement cooperation related to the investigation or the report made in connection to your trafficking. There is one exception to the 3-year rule. If the investigation or the prosecution of the trafficking case is completed earlier, you may be allowed to apply for your green card before you hit the 3-year mark. In that situation, the law enforcement agency involved in the case would need to officially confirm that the investigation is complete. For some applicants, this can shorten the timeline, but in many cases, it is actually very difficult to get this letter from law enforcement, and most applicants will need to wait the full 3 years. Once you reach your eligibility point, you can file the Form I-485, the application to adjust your status to become a permanent resident. And once the I-485 is filed, another processing stage begins. The timeline for a T visa green card can vary, but in many cases are taking about 12 to 36 months to complete. During this stage, USCIS may again schedule biometrics, which can usually happen about 3 to 8 weeks after the I-485 is filed. USCIS may also request additional evidence to show that you still qualify for this status. One important protection during this stage is that T visa status is automatically extended while your I-485 is pending. So even if your 4-year T visa period is about to expire, your legal status continues as you wait for your residency. However, it is always a good idea to go ahead and proactively extend your T visa status, even if you have an I-485 in process. Once the I-485 is approved, you officially become a permanent resident and a green card holder. Your physical green card is typically mailed about 30 days after approval. When you zoom out and look at the full timeline, a realistic estimate in 2026 looks like roughly 6 to 8 years total from the moment you start preparing your T visa case until the moment you get your green card in hand. And then once you receive that green card, this is when you start your pathway to becoming a US citizen. The key to understanding this is that your clock to becoming a US citizen does not begin the day that you get granted your T visa non-immigrant status, but rather the day that you become a green card holder. The residence since date on your green card is the date that USCIS is going to use to determine when you become eligible to apply for naturalization. For most people who receive a green card through the T visa status, the standard rules apply. A permanent resident must wait 5 years from the date they become a resident until they can become eligible to apply for naturalization. During these 5 years, the person must continue to live primarily inside the United States and meet the other requirements for naturalization, such as maintaining continuous residency and having good moral character. Now, USCIS does allow for something called early filing, which can shorten the waiting period by a little bit of time. Under this rule, a permanent resident can apply for naturalization up to 90 days before their clock for the 5-year period finishes. This means that instead of waiting the full 5 years, someone may be able to file for citizenship at 4 years and 9 months instead. Once you file this application, the N-400, your case will move through the standard naturalization process. First, USCIS will will send a receipt confirming that your application has been received, and you will receive a new case number for the Form N400. Then another biometrics appointment is going to be scheduled so that you can have your fingerprints taken and have a new set of background checks completed. Once the biometrics are completed, the case will move forward towards scheduling for a naturalization interview. This is usually the longest waiting period in the naturalization process. For many applicants today, the interview is scheduled about 4 to 8 months after filing the N400, although, of course, the exact time period is going to depend on your local field office. At your interview, the officer will review your application and they will also administer the English and the civics exam. Then, if everything goes well, then you will be scheduled for your oath ceremony, which is where you will become an official U.S. citizen. The oath ceremony is usually scheduled within a few weeks to about 2 months after your naturalization interview, and it will depend on how quickly oath ceremonies are being scheduled by your local field office and whether or not you need to have the oath administered by a judge due to a name change request. Right now in 2026, that last stage of the process is often taking about 6 to 12 months after filing the N400 until the oath ceremony is scheduled. And when you zoom out and look at the entire journey, starting from the preparation of your T visa case, ending with citizenship, the full timeline in today's environment is going to fall anywhere between 11 to 14 years. And I know that sounds long, but many of you who are going through this process thought that there wasn't even a way, and the time will pass quickly before you know it. My name is Moumita Rahman, and I have been an immigration attorney for 16 years. If you would like my help on your case, give us a call at 212-248-7907. We are based in New York, but we help clients all over the United States. Now that you understand how long the T visa process takes, you must understand what most lawyers don't even tell their clients about this case, because there are a few things about the T visa that can completely change how you approach your case, and in some situations, they can make the difference between a smooth process and years of unnecessary delay. In my next video, the top 7 T visa secrets other lawyers won't tell you, I break down the strategies, misconceptions, and hidden details about the T visa case that most people never hear about. So if you want to understand what experienced T visa lawyers look for when building a strong case, make sure to watch my video. I'll include a link to that here. Click to watch it now, and I will see you there.